vicinity of school a third-degree felony. The court ordered a pre-sentence report, and I have received that and reviewed the same. Have each of the attorneys had an opportunity to review a summary?
State has, Your Honor.
Yes, Your Honor, I have.
All right. Anything from the state regarding sentencing?
Your Honor, regarding sentencing, no, defendant is listed for first felony conviction. There is not a presumption in favor of prison. And based on that, we would ask for a call for recommendation from the parties. I would just would note for the court's own information and for probation information, this Reinhardt's residence continues to be a place where others are on pre-trial supervision with felony pending, and those that are already on community control gather. For example, recently when Ms. Pitzer left the court, she was arrested at the defendant's home after.
Don't speak, Ms. Reinhardt. You'll have a chance to speak later.
I just want to bring that to the court probation's attention.
All right.
That's all, Your Honor. Thank you.
Sure.
Thank you, Your Honor. Would ask the court to follow the plea agreement, great community control, whatever treatment the court deems appropriate in this case. When reviewing the PSI summary, it looks like my client has entered FRS and was assessed in June and started outpatient treatment July 1st. She has no prior felony convictions. She does have a few misdemeanor convictions. Looks like nothing of violence. Would ask the court based on those factors to grant community control with treatment.
All right. Now, Ms. Reinhardt, anything you'd like to say?
Yes, sir. The picture name, her daughter asked me to get her to come down here so she could be arrested. Because her daughter was upset that she was running. And I called her, they got her to come to where she could find her, and then her daughter had it set up. Other than that, I have no contact at all with anyone in the jail except for my husband, who is transferred in prison. I have put in applications, and I'm waiting to just take my drug test because I got COVID at Sugar Creek. I've already done my application. I've been going to my FRS, and I've been going to my probation. I don't miss any of it. There was traffic at my house before. There is none. It has not been time since. In this picture before that, there was time because Aaron told me what I needed to do.
All right. Well, since this is your first felony offense and your previous record is relatively minor, although I see there is a warrant for you out of Chatham County, Georgia, for a misdemeanor back in 2018, possession of a dangerous drug misdemeanor. The pickup was only in Surrounding County, so maybe there's one square bad on misdemeanor. So,
It was by the week.
okay, well, anyway, the court hereby sentences you to a term of 3 years of community control under the supervision of the probation department of the following conditions. You obey all laws of jurisdiction, conduct yourself in a law-abiding manner all the time, report when and as directed, be truthful on stage, make the probation department about your conditions. You must keep it informed of the residence place employment all the time, and not any guidance without prior permission. You not leave the state of Ohio at any time without prior written permission. You must have a copy, you must have a pass with you. All the time, you may not enter on the ground of any correctional facility, or may you communicate with or attempt to communicate with anyone who's an inmate in a facility without prior written permission to supervise an officer, and that applies to your husband. You are not to come to your conviction now. You are disqualified under both federal and state law from purchasing, possessing, owning, using, or having under your control any firearm, ammunition, or dangerous ordnance. And if you do so, you're subject to prosecution for felony under both federal and state law. It's also conditions you not have any of those items or any other weapon at the time of where you're not permitted to purchase, possess, use, or have in control any controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effects similar to controlled substance or drug abuse, nor any instrument, device, or thing that may be used to administer or prepare and for use or administration, unless you have a lawful prescription for any of those items. You must provide a copy of that within 24 hours of receipt to your supervising officer. You're to submit to drug testing when and as directed. You are not to purchase, possess, use, have under your control any alcohol beverages or be present in places where the soul being consumed, even otherwise lawful. You're not to associate with any co-defendant in this case, nor with any other person as a criminal record, member of a gang, or any other criminal group, or any other person who has the master good future unless you commit a criminal offense to violate these conditions, unless that's proven in writing by your supervisor policy. You not, you must report any contact with law enforcement or any arrest, citation, conviction, other charge of violating the law, not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay fines, fees, costs, and review. You are referred by probation department or any supervising officer for an evaluation assessment, any kind of treatment, therapy, counseling, training, or educational programming. You're to submit to that, and if there's a recommendation for any of that programming, you're enrolled in this assessment to complete that. You'll be required to pay court costs and maintain the arrangements required to do that. You'll be required to do 400 hours of community service, rate 20 hours per week, 20 consecutive weeks, unless you're employed at least 20 hours a week, a full-time student, or you have documentation from a physician or prior disability body, you're physically unable to perform that service. You're ordered to pay restitution, and you have a monthly amount of $20 per month, beginning October 1st of this year, and every month after that, it'll be paid, and that'll be paid through the, this total $60, that's going to be paid to Monmouth County Tax Force, and we'll pay those, that amount through the victim restitution escrow account. The Monmouth County Victim Defendants Office will pay any certain fees that are charged in that service. Not with being placed on community control rather than being sent to prison. Let me back up, skip one. You're to successfully complete your substance use disorder, which is SUD and entering treatment at FRS and any aftercare they recommend. Now, by being placed on community control rather than being sent to prison, you're being consented for search without a warrant. Your person, your residence, vehicles owned by you, used by you, or any property placed under your control where you're found at any time by any officer of the probation department. Now, in the event that it is, you're also to pay the court costs as a subsequent order as well, as the department pays condition. Now, in the event that the costs are not paid, the clerk like that through very means to let it on bank accounts, or whether that's what we have. That doesn't like it, then the court will do additional community service above. It's already been ordered in this court, and then you would be subject to being granted an hourly rate as approved by the court for each hour work. Each hour work, you should try to apply that amount until paid. Now, in the event that the probation department feels that you have failed to comply, they can return you to prison. They can file a written notice of that court, serve a copy upon you, and there will be a hearing. You'll be about to have an attorney at that time. If the outcome of that hearing is that you have failed to comply, then at that time the court can, if it makes that finding, revoke it from your control and send you a prison term of 29 and 36 months, fine $10,000. If that happens, upon completion of your prison term, the adult parole will leave may exercise the option to be under close police control for a period of up to 2 years, and if they do, and they find that you have failed to comply, you're in prison, even though you serve the entire term set by the court, for additional period of up to 9 months for one violation, and the maximum 1.5 years for all violations. However, if you been in felony on close police control supervision, then an additional represents the judge in the case of imposed fine. The judge can also authorize extension in this case for an additional period of 1 year, where time left on that period of close police control is ever greater. That occurs, that must be served consecutively sentenced in the case. The court also imposes a mandatory fine of $5,000. That would be paid to the percentages of, we have a percentage of this policy.
No, I don't, but I'll do it next week.
Okay. All right. Is there anything further to the council? All right. You are now off of community control. Need pretrial supervision on these conditions. So you need to follow the probation officer to make as soon as you're done quarantining and recovered from your COVID. Have any questions, Ms. Reinhardt?
Thank you.
All right, thank you. All right, I think that's our last hearing.
That's correct, Your Honor.
All right. Dave Lyon versus Christie Murphy. Case number 22, CR 113, Dave Lyon versus Christie Murphy. President of the state is Assistant Prosecutor King, President Attorney Danielle Litt, and I view Christie Murphy.
Sure.
I think Ms. Murphy has entered pleaded guilty to theft from a person in a protected class, violation of 913-281, equal to felony. The case is referred to the probation department for a recent investigation and received that report, and each of the attorneys received a summary. State Attorney.
Yes, Your Honor.
All right, Mr. King, on behalf of the state.
Only was contained in a plea agreement, Your Honor. The victim, Louise Curtis, is present in the courtroom this morning and would like to make a statement.
All right, Ms. First. Go ahead. Would you like to say something, Ms. First? Go ahead.
Never in my life would I have ever thought I would be speaking in a courtroom at my age of 87 years because I was stolen from by someone I knew. This was not just a theft. You stole my checks. You wrote my driver license on them, forged my name, to which you did not even spell correctly. You connected my account up to PayPal. I do not even know what PayPal is, and you tested it 3 times to make sure you would be able to get money out of. You connected my account to HR Block. I have not filed taxes in years. What you did not account on is that I balance my checkbook every month the old-fashioned way, and I am very careful what I spend. I found items on my statement for purchases I did not make. I finally told my daughters about the checks I did not remember writing. I was embarrassed at first to tell her, as I thought I was losing my mind. I told my daughter that Christie Murphy had been to my house and had asked to use my old-fashioned typewriter to type up something to get her place. I went to take a shower, and when I came out, I noticed my purse was not in that same position as before I got in the shower. My daughter told me that no one Christie's age uses an old-fashioned typewriter. From that moment, we knew it was Christie. We just had to prove it. We reported it to the sheriff's department right away, whom immediately began working on the case. We closed my account and had to contact Social Security, the place in Germany that I received a pension in 2 other accounts. These took months as I could not remember where 2 of the deposits came from and had to do a lot work to find this. I have seen a side of myself I have never seen. I whimper and I cry almost every day, feeling weak and foolish. My heart has physical pain, and I've been to an emergency room and to the doctor, for they keep asking my daughter, why did she do this to me? You shameful criminal. the monies you stole from me over 1,800, to which you will not have to pay back as the bank reinstated my money and FDIC, I'm sure. So they will write me money off. So you walk away having to pay nothing. You thief, you. I only have a few years left in this life, and you have made my life miserable. I went through World War II, had a basement to get away from the bombing in Germany, and have still remained strong. And now, thanks to you, criminal activity. From what I understand, the law will not put you in prison because you have no prior felony. Yet there were 2 pending felony charges, and the prosecutor offered a plea bargain. You belong in prison. We have contacted the Attorney General office and have been instructed to contact Shane Wilkin in the matter of the protected class, elderly in prison for this. We will be fighting to amend the law to include prison time for those that abuse the elderly. We ask the courts for the maximum sentence for jail. From what we have been told, the courts do not try to send the criminals to jail because of the cost. Yet time and time again we pay for the sheriff, the prosecutor, and the courts, usually for the same criminal over and over. I believe here in Hillsborough we can set the standard for protecting our elderly as we deserve this. Let these criminals know that they will not violate our elderly without going to jail in our town. When you lost custody of your children last year, you should have gotten a job instead of stealing from me. I would have given you anything you needed. I trusted you. I'm 87 and the great-grandmother of your children. Once again, Your Honor, we would like to ask for the maximum sentence in jail. Since she does not have to pay the 1,800 back, she can pay for her jail sentence with that money, even if she does a year of work in jail, if that is even possible. She passes every drug test given to her by Children's Services, and this crime did not involve drugs. How do you rehabilitate? In closing, we would like to thank the Sheriff Department, the prosecutor, and victim witness for all the help they gave us. My name is Louise Curtis, the victim, the great-grandmother. Thank you.
Anything else to say?
No, Your Honor.
Ms. Webb?
Yes, Your Honor, we do ask the court to follow the joint recommendation. This is Christie's first felony conviction, and other than this, she has, I think, minimal misdemeanors, just 1 or 2. So she has otherwise led a law-abiding life. And she has expressed to me that she is remorseful and did apologize to the victim here, but would also hope to do that to the court as well.
All right, Ms. Murphy, anything you'd like to say?
I just want to say I'm truly sorry to Louise Curtis. And
Speak up, please. Speak
I
up.
just want to say I'm sorry to Louise Curtis for everything that she can't trust me, but I just wish I could take everything back. I'm sorry. I'll pay her back whatever she wants me to give her.
All right. Any further? Well, unfortunately, under the Article 86, which changed the law back in 2011, people without a previous felony conviction, they're convicted of 4 to 53 felony in opposite prison. Prior to that, I often said people have been trying to get so person that not able to do that unless there are certain things that occur after they're put on bail, and that not occurred. So I'm required to grant me control. So it's the word of the court that you be put under 3 years of community control supervision of the probation department under these conditions. You obey all laws of all jurisdictions, conduct yourself in all fine manner, always, or to outline you are to report when and as directed, including all statements you make in the probation department, as well as any answers you give to questions they ask you about your community control. You're keeping informed of your residence, place, and employment all the time, and not saying right without prior permission. You're not leaving the state of Ohio anyone without prior permission. You're not entering on grounds of any correctional facility or may communicate with or attempt to communicate with anyone who's inmate in those facilities without prior permission. You're not permitted to purchase, possess, own, use, or have or control any firearm, ammunition, dangerous weapons, weapon of any other type. You're not to purchase, possess, use, or have or control any type of controlled substance, drug abuse, CBD, or kratom, or any urine or anabol, of any controlled substance that has effects similar to controlled substances, drug abuse, or any instance, device, or thing that may be used to administer them or prepare them for administration unless you have lawful prescription, copy of which must be provided to the supervising officer and then put our proceeding. You're to submit drug testing when it is directed, not purchase, possess, use, have under control any type of alcoholic beverage, only in present place of the soul may consume these otherwise lawful, not to associate with any not associate with any person as a criminal record, member of gang, or a criminal group, or any person as attached with abuse or cruelty to criminal offense violating this condition, such as proof of writing or supervising officer. After the date of this order, you may not marry or establish cohabitation in a common law marriage type relationship with another without written permission. You must report any contact law enforcement, any arrest, citation, conviction, or the charge of violating the law on later than the next business day after that occurs. Provide your supervising officer with financial information records so your ability to pay fees, fines, and costs for review. If you are referred for an evaluation or assessment of any type of treatment, therapy, counseling, training, or education programming, you're submitted that, and if any programming is recommended, you're to enroll in and successfully complete that. You are paid for costs of this action, and maintain the arrangements with the court to do that. And see that so restitution, there's the restitution act under the very one. All right. Now, while I'm not permitted to send you to prison, I am permitted to push you to jail. Could push you to jail for up to 6 months. I don't think that makes a lot of sense because the taxpayers will be fully billed for that, and he's on disability, so that is unlikely under the law. But the court does feel that there needs to be some punishment that means what you've done, which is abuse of the trust of a family member, and who offered a home to you, frankly, to your children. And so the court orders that you serve 30 days by the county jail. Now, being placed on community control rather than being sent to prison for deed consent to a certain amount of warrant of the person, your residence is owned by you, used by you, or any other property place under your control where you're found at any time in the house or probation department. No fine imposed. Now, you're also paid for costs of substance order. You have to do that for a court order you can service any form of disability condition. And if that occurs, you could earn credit for your work and not really set up 45 work. Now, in the event that probation feels that you have failed to comply with these conditions, then they will file a red notice of that with the court or a copy of it on you, and there will be a hearing which will be held at the court. If the outcome of that hearing is that you have failed to comply, then at that time the court will revoke control and then send you to prison for between 6 and 18 months and fine you $20,000. If that happens, once you complete that prison term, the court as part of the sentence could exercise the option to put you on post-release control supervision for a period of 2 years, and the duty to be supervised by a law and permanently set. they determine that you failed to comply, they can return to prison, making sure that this period about 9 months according, one violation caps after whatever term is imposed. So that act could be a fine of percent less than 18 months cap for that. Now, if you've been indicted on approaching choice, then in addition to whatever sentence the judge indicated, that judge also sentence you for fitting that new offense for unappropriately control this case with an additional period of 1 year, whatever time left on that period of 2 years of appropriately control up to 2 years. Whichever is greater, and if that occurs, that's a certain second sentence. All right, is there anything further, counsel? You're remanded back.
Step back to the deputy's point, please.
Justice Conley. Case number 22-CR-116, State of Ohio versus Justice Conley. Present on behalf of the state, prosecutor team. Present on behalf of the defendant, J. Wagner. And you, Justice Conley.
Yes, sir, I am.
Mr. Conley has entered plea guilty to counts 1 and 3. He's actually attracted methamphetamine in the vicinity of school. Third degree felons. Matter of recent investigation. Court has received that and needs to return it to the summary. All right. Anything from the state?
Only was contained in the plea agreement, Your Honor.
Right.
Your Honor, I guess I want to say, dumbing it down for me, I truly like my client. He's kind of a breath of fresh air. He's never once denied his allegations. I mean, he admits to them the first day we met each other. He's been a poster child of how someone should behave. Not saying these allegations, they're not allegations, they're true. They happened over a year ago, around July 14th of 2021, Your Honor. Justin on his own, maybe we didn't even know about this when he got clean. He's 11 days short of being clean for a year. He did this on his own. He's been an exemplar while on pretrial supervision. He's in treatment right now. I mean, every time I call him, he's at my office. Every time he's in court, he shows up. I think the court even took a chance on him, which kind of blew me away, which I'm glad though. He's got a nephew that has a heart issue. He's a transplant. This court allowed him to go to a Make-A-Wish Foundation trip with him. Justin appeared. Zero problems whatsoever. He's been here with family. He didn't show up to me today. Hey, Wagner, take it down the road. I got to get my dog to bed. I mean, he's just one of those guys you truly like. You wish every client would accept responsibility like this. Again, I know this is an agreed upon statement, Your Honor. We're not asking the court. I'm not making a pitch. I just want the court to know about him. I hate it because it was a year ago, over a year ago that he screwed up, and that's the way it is, Your Honor. This guy has admitted everything. Again, I just sincerely, I mean this, Justin. I wish you the best. Stay strong. He's a great guy, Judge.
All right, Conley, anything you'd like to say?
Yes, sir, Your Honor. First off, I'd just like to thank God for the opportunity to be alive here. The way I was using drugs a year ago, I was dying 3 days a week, and I just didn't want to live like that anymore. I knew I was going to die, and this could happen. Just grateful to be alive, and some people might think I got it too late, but I got it, and couldn't be happier. I built more memories in the last year than literally I have my whole life, and I just don't want to live like I used to live anymore. I'm hungry, and I just ask them to be fair with me. I'm sorry to everybody that I've harmed, because this could could have been a lot worse. If I'd have kept using drugs, I probably wouldn't be here, or the criminal activity here just kept getting worse and worse and worse. I'm grateful for the time I've got to spend with my family. It's clean and sober. That's all I got here.
Well, Mr. Smiley, you aren't being commended for taking on yourself particularly, instead of waiting to get arrested and working, but that's always a thing. And unfortunately, you pass catch up. Probably there's a lot more that haven't brought up to you, and probably it's not because you're not going to help account for these messes and basic punishment for that. And congratulations on almost 1 year of being like that is quite an accomplishment. You should be proud of yourself. And I know this is not the first time you've been, probably won't be the first time. You had back in 2012, I asked you, you had to be controlled by that person. You had to be control of this work or that charge 9 times where it was successfully passed. But again, this conduct is pretty extensive and perhaps some kind of work. But work is perhaps what you've done so far. Hopefully you continue to do that. It's a judgment on the court that you be sentenced to the correctional reception center for a final court period of count 1, 24 months, and count 3, 24 months for both. Served secondly with a total of 48 months. Court finds that second sentences being imposed is supposedly a recommendation for that. Also, the court finds that the investigation part of the court's conduct for several transactions, and that one single sentence will not accurately reflect the seriousness of the conduct or the harm that was caused, and the sentences being imposed to be within range sentence or not proportionate to the seriousness of the harm caused. And also the previous criminal history demonstrates the second sentence transfer. According to the sheriff, you will be pressed on 12 today, and please on 18 for that correct. There's to be around 6 days of jail time credit. Now, on completion of the prison term, the whole authority for the sentence made exercises right to socially control supervision for a period about 2 years to do supervised term they set. During that period of time, term that you have failed to comply, you have been prison. Ensure the entire set by the court for a completion period of up to 9 months by 1 violation up to a maximum act. And the prison term would be 24 months for all violations. However, if you violate by completing these minutes of felony, or both these both prison, then an addition whatever sentence you have in this case proposed money, the judge is also offering you to an additional period of 1 year or every month left on the social control period in this case for committing that new offense on the occasion. If that occurs, that is sort of effective sentence in the case in addition to. Also, we pay court costs for judge grants, and if you fail to do that, court go over to the clerk for that first means, including levy on bank accounts, wages, earnings, or other assets you can have. That does affect it then upon completion of your sentence, the court for you serves not while you're in jail, once you're out, and you credit for having that in this county. You would give credit for your entire work in and out of this for entire work that you should apply that. You also order a restitution, joint several with code that $480.94 paid to the task force. Those payments are to be made through the victim witness escrow, restitution escrow account to pay and service fees that are charged for that. Now, the court does make as a notice they can oppose judicial release after you serve 9 months. Could file maybe 8 months and take these sort of days that have with hearing on that. Not promising it's granted, but everything you've done so far is a good indicator to the court. So continue institution, try to continue with their recovery, and the court will possibly take that into consideration. Increase like Brandon promising that, but I think that's a decision based on what I know in the future, but I don't know what the future. All right, is there anything further? Oh, you were going.
I was appointed, he's
Financial situation has changed. What, right, the court will find that it's not able to pay it, or it's not like to be able to pay it in the future, that will have to be. All right, your name's that.
The fact that also.
On page.
Great, Your Honor.
You may.
Thank you. Thank you.
Case number 22 CR 120, Big Wow versus Lonte Ames. President of the state is King. President of the defendants attorney Armin Brown. You are Lonte Ames.
Yes, sir.
Mr. Ames is under plea of guilty to aggravated trafficking methamphetamine, a third-degree felony, for the first matter for a pre-sentence report. I have received that and reviewed that. Have each of the attorneys received a summary.
Yes, Your Honor.
Right, anything from the state regarding sentencing?
All those in with the agreement, Your Honor.
Right, and then let's see. The restitution is $170.
Yes, sir.
Right. Mr. Armstrong?
And we ask the court to follow the recommendation made by the state of Ohio. As Mr. Ames on community control, he's a good candidate for it. He's completed your inpatient rehab, is that correct? Your transitional living now?
Yeah, I split it 16 days.
Been given an opportunity by the state of Ohio here, you are, file accounts with his parents, the way he speaks to me, he's turned his life around, and hopefully the court will be going to send over this.
All right, Mr. Ames, anything that you'd like to say?
No, sir.
And you're still in the transitional program at another chance, right?
Yes, sir.
And be working still copy that whole time?
Yeah. Yes, sir.
It's the order judgment of the court of the defendant being is hereby sentenced to a term of 3 years community control supervision under the probation department under the following conditions. First, must bail all provisions that all bar and all time. The court will then ask directly to be truthful in all statements made to the probation department for all questions, answer questions be able to ask. You're keeping informed of the resident place at all time, and then change out without prior permission. You may not leave the state of Ohio at any time without prior written permission. If you receive that, ask, doesn't have it with you at all times. You are out of state. You are may not enter on the grounds of any correctional facility or communicate with or attempt to communicate with anyone within the facility without prior written permission. You're not permitted because of your conviction to purchase, possess, own, or use, or have under your control a firearm, ammunition, or dangerous ordnance. If you were to do so, without first getting that moved in another separate legal proceeding, the subject of prosecution under those state and federal law or an addition of. Also, the addition does not have any of those items or any other weapons that you have on your own control. You're not to purchase, thus use, or have in your control any controlled substance, drug abuse, CBD, oil, creative, or any variant or analog of any controlled substance that has an effect similar to a controlled substance or drug abuse. Nor may you have any other instrument, device, or thing that you use to administer them or credit administration unless you have a prescription. If you do, provide a copy of that to the when we're already proceeding. We're still protesting when it asks a question by the probation department as well as the treatment department. Your purchase, may not purchase, possess, use, have, and control any alcohol beverage should be present places to be sold, being consumed, even if that is otherwise lawful. You're not to associate with any food defendant in this case or any other person has a criminal record, member of the gang, or a criminal group, and a person has a passion for the future, unless you commit a criminal offense or violate these conditions, unless you have approval of that in writing from the supervising officer. That would apply to family members involved in the definition of prior conditions. After the date of this order, you may not marry or establish cohabitation of normal marriage relationship with another without written permission. Does report any contact law enforcement or arrest citation commission of charge violating law on later than that occurred. You may provide, not provide, or supervise officer of financial information records to your facility containing fines due to positive review. If you are referred by probation or any further evaluation set for any type of treatment, therapy, counseling, training, other education program, you will submit that. And any treatment or program is indicated the goal is successful. The court cost of this action may take arrangements to do that work. Pay restitution through the victim witness escrow account, monthly payments, $170, so say $30 a month, beginning September 1st. Or not that back, pay the fee is required for that, or pay restitution point several with the code amount of $170. You have, each of you responsible for paying the full amount that he doesn't pay his half, or she, I guess, is, and you're responsible for paying the whole thing, and then you have to sue her to get your half, or half back. As the law says, the defendants have to go after each other instead of court, in this case, the state. Here's a successfully complete your transition to your level, your SUV, substitute for treatment and aftercare at ACM. Now, by being placed in control, rather than being sent to prison for any redeemed, sent to serve without warrant, the person must be somebody who used by you. Any other proper places under control where you're found at any time. Mandatory fine $5,000, you pay that, and make payments on that, and you'll have 3 years to do that. So that would be August 2nd, 2025. We know suspension of license. And the court costs if you do not maintain the right time, pay those in addition to what the violation of control could be collected by the clerk, by a liberal bank account, wages, or other that court service. Give you credit for each hour work, not rest that for each hour work, you should verify that amount. Now, in the event that it's alleged to have applied these conditions, Mr. Ames, the probation department, or and the probation department file records that the court sort of pop down to not have hearing, and be represented by an attorney at hearing. If the outcome of the hearing is to go blind and not for control, since you have a prison term between 9 and 36 months, and by you $10,000. If that happens, once you go to prison, serve that prison term, the full authority may decide part of the sentence for supervision for a period of up to 2 years. That's up to them. If they do, you can supervise them with the term that they determine. You fail to comply, and they attorney privity will serve the entire term of the court for an additional period of up to 9 months or 1 violation, which is half or less than half whatever term of prison awarded by the court for all violations. However, if it's a felony, then an additional sentence adjustment and adjudication of the judge can also send you for committing that offense while unlawfully control the station condition for 1 year or time left on them, which was controlled to greater that person must be served exactly the sentence in the case. All right, is there anything from the council?
There you are.
Now terminated pre-trial supervision and the court probation department is here. Well, no, you can sentence in control so they can sign you to a probation officer. That's all.
Yes, Your Honor.
You guys, all right, Madison County Health District versus Conning County. And,
Judge, one of those arraignments also has a hearing this afternoon at Johnson. Do you want to pull his and
yeah, we'll get a full in that.
just go ahead and have him this afternoon and get the other two in this morning? Does his attorney need to be notified? Oh, okay. Okay, good.
All right, case number 41 CD 172, Highland County General Health District versus Connie Henderson for the plaintiff, assistant prosecutor King. Webster also plaintiff, and you are Connie Henderson.
Yes.
All right, 10th hearing, it looks like back on the February 28th, the court granted a judgment in favor of the plaintiff against you, Ms. Anderson, requiring that you pay nuisance of located at 11445 Country Road due to solid waste violations and you restrain any further waste on premises. You have 60 days to remove that, so that would have been there was a motion to file with, I think that was contempt, filed by the plaintiff on May 17th. And set at the hearing on July 6th. And court continued the matter as you requested of that. And scheduled the hearing. Now, as far as plaintiff's position, has been a change in circumstances since you talked with the
They are on the property now.
Has there been any private that also since your original order?
Yes.
I would say yes, but it's been moved across the street.
It's what?
It's been moved across the street to complexities.
So what's the situation right now with the condition on the
There's still solid waste structure. There's a substantial.
Alright, so have you, What was the reason you haven't been able to leave that? I mean, I understand your mother died,
Your Honor, I got rid of most of the trash that was there. I had a trailer that was full of trash in the truck, and the truck is back over at its residence. The trailer is gone. The front yard's clean, the side yard's clean. I'm getting the garage back behind the garage tonight, and then we'll be done.
yeah, when was the last time that trailer was left?
Today,
Got pictures?
yes, sir.
Of Marcos, those announcements, showing her. And, once you have, all the habits for West, stand, raise your right hand, this morning. This morning, and, you saw for the testimony about the,
Yes.
all right.
Could you please state your name for the record? Oh, well, are you currently employed? And are you familiar with the property located at 11445 Denby Road in Hammond County? And do you know who owns that property? See, Ms. Henderson, for today? Yes, sir. Before we took her, record like witness identified defendant. When were you last at the property, on Dudley Drive, this morning? Did you take photos of that property? Yes, sir. And you would have been marked as plaintiff's exhibit 1 for identification purposes. Do you recognize that? Yes, sir. What is that? It's a short full of solid books. And you would have been marked as plaintiff's exhibit 2 for identification purposes. Do you recognize that? Yes. What is that? Picture of national solid waste on the property there. And our plaintiff's exhibits 1 and 2, true and accurate depictions of the property of 11445 Denby Drive appeared on August 3rd, 2022. Any further questions?
Your Honor,
Would you like to ask him any questions, ma'am? You can touch on your own after that.
the question that I would like to ask them is, there has been improvement on the property.
Let's ask the question.
No, Your Honor, I don't have any questions to ask you.
All right.
I have something
Oh,
to
that's
do.
right. All right. Yeah, any witnesses?
Yes, sir.
Of those witnesses,
Yes, sir.
we've been, brings up before.
Correct, John?
Okay. All right, now, you wish to, if you would, stand, raise your right hand, swear you're going to see, that's fine. You, also attest about the,
Yes.
all right, and you tell me, made a statement on whether that was an excuse, or that's why it was on, here, what's going on, this picture show, a lot of junk still there in the property, and others more.
Your Honor, the trucks are gonna be gone before the weekend. Someone's coming to take the trucks out. I've got that arranged. The side yard is clean, the front yard is clean, and as I said, I will have the backyard done tonight.
There's an awful lot there all day. But why haven't you, I mean, this was, I think, back in what, February? So, I guess they had a table, had another 3 months on here. What's the problem?
I've been taking care of my mother before she passed away.
Or was she,
Living with me.
so she lived in this property? All right, what we're going to do is take this hearing progress, and see, I ain't gonna find the tree, yeah. But I want to withhold, order, as to, action, until, you see if you do hearing, say what you say. So, the, court will continue this matter, until, and that's Thursday at 11 a.m. And, well, I'm sure we'll get property the day before for that morning, take more pictures, so, you know, you need to get there. And I will say this, acting under everything moving off of your property is not a solution, it's supposed to proper matter. What I would suggest, Mr. King, is in the future that you make sure that the entries or signs corrected as you split up in a matter authorized by law. But if you know this is beginning to be a shell game, I see where people are moving across the road to different places. And so, actually, you know, the order doesn't say, it just says pay. I know they can be sued, they can be re-prosecuted for getting a new violation, but that seems to be able to be short-circuited within the interest of the future. So, all right, so we'll be here next Thursday, 11 at 11 a.m. If you have anything up there, sanction will be minimal. If you don't, you'll be subject to being sent to jail for 30 days, plus fine for $100. All right, thank you.
Thank you.
Yes. All right, check out here.
Yes, here we're good for. Yeah. Good point.
Well, Your Honor,
Yes.
she hasn't stated her position that she's tested positive for COVID. You want her
No, you should be here.
in the courtroom or?
No, I don't want her here.
Okay.
You had to go home, you know, and settle with them. We'll we can continue your case.
Serious.
No, just take it, right? All right.
I had one of the guys that
How long ago was it, mistake?
Today, 9:49.
Does the other one need to sign a notice up here?
Yes. I never gave her one. You gonna give her
We'll
one?
get those rings set up, Dan.
Okay. She out there.
Yeah. What's the date?
Next, it'll be the 11th at 11 a.m.
What was her name?
Connie Henderson. Did you call the jail yet? Johnson.
Okay, this is case number 22 CR 167. State of Ohio versus LC Johnson. You are Arnold Charles Johnson, correct?
Correct.
All right, Mr. Johnson, you were indicted by the grand jury yesterday morning on a charge of grand theft of motor vehicle, fourth degree felony, allegedly on about I-7 this year in this county. Did refer to private William Club, 2004 Chrysler Townhouse Minivan, knowing they intended to control without value consent. That is a fourth degree felony, which convicted carries a possible prison term of 26 and 18 months and a fine of $5,000. Now you're entitled to appointed counsel. I see you have filled out a financial disclosure form. I know when we had your case last week, the other case you had. So this time you are requesting court to appoint counsel for you.
Yes, sir.
All right. Court will appoint Attorney Jacob Wagner until Ohio to represent you in each case. We had you set this afternoon for 7 o'clock on 147 case that I raised on last week. So we will not need to have you in for this afternoon. So officers will do him for less this afternoon. We'll enter a not guilty plea on your behalf to this charge. So you're being held in your other case for $2,500 bond. So I'll set bond in this case for $1,000 plus your OR. Use your promise to appear, and if you never appear, you could be prosecuted for additional felony. The other conditions that require release also apply. Plus $171 deposit, statutory required fees prior to release. And if you do make bond, you can work away part, you shall report legally upon release. 1 week or 4 weeks, and after that, they determine that the rank drug testing by a phone number from the employer, no contact with that victim, evaluating substance abuse, elevation, increase indicated enrollment, and all that defense and sanction, and also being house arrest of the residents. And 7515 Evans Road, we get to all the time, when it's working, withdraw work, medical appointment, court proceedings, this or any other case, appointment, attorney, probation officer, deciding the case, and school, job training, education program, and church service. Today, I think we have a long review here, except for you at 9 a.m. On Friday. It'll be August the 5th. That'll be in front of the magistrate. First pre-trial then will be set for August 17th at 1 p.m. I'll be a Zoom hearing. Final pre-trial will be September the 21st at 1 p.m. by noon. And set the trial date of October. October 31st at 8 a.m. The other case is set earlier after this separate case, so private. Separate. All right, we'll notify your attorney of his appointment. Mr. Johnson will have a hearing from the magistrate Friday morning on the bond. Thank you.
Next.
All right, case number 22-0143, State of Ohio versus Levi T. Krabs. You're Levi T. Krabs?
Yes, Your Honor.
All right, Mr. Krabs, you were indicted by the grand jury yesterday morning on a charge of intimidation an attorney victim or witness in a criminal case under 2921.04 B3 High Code, third degree felony alleged beginning about May 5, 2022 through May 31, 2022 in Miami County, knowingly by force or unlawful threat of harm to Nancy T. Collins for property or by unlawful threat of any offense including against Nancy T. Collins and attempt to plus intimidate or hinder Nancy T. Collins, Nancy T. Collins, an attorney, or even the attorney involved in any criminal action proceeding, violation set of the 2921.04 B3. So that's third degree felony with conviction carries possible prison term between 9 and 36 months, fine of $10,000. So your time to have an attorney represent you, and you fill out an attorney form. And also, this new indictment, since it involves the prosecutor, your attorney in the other case request to be withdrawn from that case. The court has just this morning heard that Mr. Bruce Wallace is really experienced attorney from us, or will agree to take your case. So I'm going to appoint him in both cases. And in this case, I'll order him not guilty plea on your behalf. Not going to set a schedule at this point because my assistant is working on that to Mr. Wallace's office, and there's a special prosecutor, and so I'm going to have to let her get that set today and do that by assignment notice. Bond will be set in the amount of $20,000 plus your own cognizance, which is your promise to pay here in the federal here. You could be prosecuted for additional felony. You'll be required to pay a service fee of $171 prior to release to make bond. On both cases, you'll be under pretrial supervision, report to the probation department, 117 Main Street, immediately upon release, and once a month, 1 week, 4 weeks after that, they occur. Program drug testing by current on-site employer, have no contact with the victim. Recommended by probation to evaluate substance use and mental health issues, any treatment indicated, will then follow ever intensity of sanction. Main bond will also be in house arrest at your residence, meaning you have to be there all the time unless you're working, going to and from work, medical appointments, work proceedings, in this or any other case, probation appointments with this or any other case, or appointment with an attorney in this or any other case. And you may attend kind of educational programming or job training. And church services, other than that, you have to do it all the time. Alright, like I said, your attorney knows you've been appointed, and we'll get those hearing dates set, hopefully today. But since we have a special prosecutor from Columbus and an attorney from Mount Orr, it may take a few days to do that. We'll have it determined. Alright, thank you.
Is there a bond review hearing on that? Is there a bond review? Yeah, getting everybody together would be.
We can't get the number.
Are you paying G. Pitzer?
Yes, sir.
This case number 22-169, State of Ohio versus Nancy G. Pitzer. Pitzer, you were indicted by the grand jury yesterday morning on a charge of aggravated possession of third degree felony alleged on about April 6th of this year in Miami County, Ohio. That you normally obtained possession or used a Schedule II controlled substance in an amount equal to a receiving bulk amount, but less than 5 times bulk amount. 25.11 High Code. That is a third degree felony, which if convicted carries a possible prison term between 9 and 36 months in a fine of $10,000 and for a fine of $5,000 and a possible license suspension of 6 months to 5 years. Now, a significant one-on-one child represents you in your other cases. Was he appointed or you appointed?
He was explained to me April 6th.
Yeah, that's right, okay. All right, so the court will appoint him in this case and enter a plea not guilty in your behalf. And I know you're in jail for contempt sentence, that you have, I think, a bond in the other case, so, in this case, I'll grant you no warrant only, which is your promise to appear, and if you fail to appear, then you could be prosecuted for an additional felony. You're also, required to pay a service fee of $171 prior to release. Or not, within 30 days, I'm sorry, not prior to release, within 30 days. We will set a, first pre-trial in this matter for, August the 17th at 1 p.m. Thank you for Zoom. Because, you haven't been able to do that otherwise in person. So we'll have your second pre-trial on September, 21, 1 p.m. And the trial date is set for October 31st at 8 a.m. All right, we'll notify Mr. Armstrong this new case and the scheduling, and same conditions of pre-trial supervision apply in this case. So as soon as you get out of jail, your contempt sentence, make sure you report probation immediately the same day, the next business day, and then apply to those conditions that you have any questions?
Yes.
All right, thank you.
That's it, yes.
Oh, we'll see you in person. I think that's it.
That's it, yeah, he's not on